This is a partnership between the Montgomery Bar Association and the Norristown Chamber of Commerce. And I really appreciate Evelyn and Nigo for reaching out and starting this partnership and getting it going. We did start it, I guess, kind of last year, but it's taken a while given the COVID situation. But I thank you all for hanging in there with us and to kind of jumpstart this for the new year. Also want to thank Marilou Watson for being our first presenter here. Our small businesses are really challenged, as you all know, and the legal services of what our needs are, especially in the minority communities or underserved markets, are more of a need now, and it's become more prevalent of what we don't know and what we should know and who we should contact. So I thank you all for partnering with us in Norristown and look forward to more of these events. So I'll pass it over to Evelyn now. I think I saw Nigo, but he might be in court. So I really thank you all for your time, and I'll send it over. Thank you all, and have a great holiday season.
Thank you, Chamber of Commerce. Thank you for having us. My name is Evelyn Rodriguez Devine. I am a civil litigator, a Spanish-speaking attorney here in Montgomery County. I own my own firm in Bluebell, and we specialize in civil disputes. I am a member of the Montgomery Bar Association, which is essentially a group of members, attorneys in Norristown, and part of our mission is to partner with our community members and our local business community to make it just a little bit better. I'm happy to join in this effort today to bring you the first of a many series of what we hope will be presentations in pertinent legal fields, which will help you as business owners perhaps be a bit more savvy, smarter, make you a better business person, make you paranoid in what you do, and perhaps get you thinking about where you, your employees, your customers may be most vulnerable, and whether you really need to call that attorney to protect your business. So my Puerto Rican father used to say, Evelyn, you can't win with rookies. So I'm happy to present a very seasoned, experienced attorney who specializes in intellectual property. Marilou Watson is a partner at Fox Rothschild, a pretty hotshot law firm in Philly. Thankfully, she's grounded because she practices here in this county in a satellite office, right here in Bluebell. She practices intellectual property with a background in advanced pharmaceutical technology. She graduated in our county from Villanova Law School in 1984. And today, her mission is to help us understand the world of property protection. And that property can be in the form of design, innovations, ideas, inventions. She'll discuss filing patent applications, how to protect others from stealing, duplicating our inventions, and why it's important to not only have a trademark, but to protect your brand and to protect that trademark. She'll discuss trade secrets, and she will demystify trademarks, which are things like unique recipes, could be just that simple, a method, a process that's unique to you alone. She'll discuss how do you protect those things under the law? What is a copyright? And why they may be important in your line of work. Rights of distribution of copyrights. She will discuss these issues. So let's sit back for the next 40 minutes and learn a little bit about things that may be important to growing and protecting your business, my business, our business. I will take questions via the chat room, and I'll be happy to run through those questions at the end of her presentation. And again, thank you, Chamber of Commerce, for allowing us this opportunity. And with that, Marilou Watson, take it away.
Thank you so much, Evelyn, and thank you, Kim, for just initiating this partnership and giving me the opportunity to do the first presentation in this particular series. And I don't take it lightly that I have this opportunity to speak to business owners, because I know this time more than any is a very challenging time. Everyone is pivoting during this pandemic, and one day, you know, the rules may be in one direction and then they change the next day. And so I commend you all for having the courage, first of all, to start out and form your own businesses. It's no easy undertaking, and recognizing that there are some businesses that only are still just business plans. So you have to have that courage to really step out. The other thing that I'm going to mention too is that one thing that I've found that has helped me quite a bit, especially during this pandemic, is helping others. A lot of times, of course, we're focused on our businesses and so on, but personally, I've found that when I reach out to help others, that it comes back around full circle. So I would just recommend that you do that and consider that in your business as you're trying to continue to move forward during this pandemic, recognizing that your fellow business owners are doing the same, and there can be much strength in numbers. And lastly, be creative during this time. And there's a saying that necessity is the mother of invention. Well, that's all about what I do and why people come to me to help them protect their intellectual property. And intellectual property is distinguished from real property because, of course, intellectual property is those things that you create with your mind and your creativity. And so now I will get a little bit further into some of the things to be mindful of and exactly what is intellectual property. So intellectual property is classified in basically 4 different areas. You have copyrights, trademarks, patents, and your confidential information or trade secrets. So why is it important that your company protect your intellectual property? Well, you want to make sure that you aren't precluded from selling your products or even your services and so on in the future. And you want to be able to, enforce your rights in what you've created against others who may try to infringe on your rights. It allows you to build your market value, and additionally, many of you may seek venture capital to get your business started. And many times those banks or those angel investors want to see what it is that you have and what's protected as it relates to your business. And it basically keeps your competitors out of your backyard to a certain degree. So what does copyright law protect? And I'll go through each of those areas as I listed them at the outset. So copyright protects original works of authorship, whether it's software manuals, publications, blueprints, web content, graphics, videos, and so on. But what's really key to remember in protecting your copyright is that those works that you create have to be fixed in a tangible medium. So what do I mean by that? It has to be recorded somewhere. It has to be written down. So you may be a poet, and if you create a poem in your mind and you never write it down, you have not achieved any type of copyright protection because you have not fixed it in a tangible medium. Same thing with a photograph. Your eye is seeing what it is you're taking a photograph of. And once you take that picture, whether it's digital or you print out a copy, that's when it is fixed in a tangible medium. And another example, I'm sure many, if not most of us, have gone to a concert. And of course, at the beginning of a concert, we're told that, you're not allowed to record. And part of the reason that is because it's saying to the world, you don't have permission to copy what is being performed. But it's a bit of a safeguard also for artists who, some of them kind of go off script and may start to create something new or ad lib, and it hasn't been fixed in a tangible medium and they have not pursued a copyright. And so by making that statement at the outset, that gives them a little bit of protection. And also it's important to know that once you fix something in a tangible medium, you immediately have a copyright. However, that is common law copyright. And so just by creating that work, writing your poem, say you write music, lyrics, or even the melodies, once you write them down, you have a common law protection of your copyright. However, let's go to the next section. And what that does is it protects your expression. But the issue is that if you do not file for copyright protection through the Library of Congress, getting a registered copyright, you are not able to collect damages if someone copies your work until that registration has occurred. So give you a quick example where someone had contacted me. She was an artist and she painted a very colorful and beautiful picture. And someone was in a kind of like almost a Dear Abby group chat, giving people advice about things that they can do to kind of lift their spirits and so on. And one of the things that this person said was, you can surround yourself with bright and colorful artwork like this. And they put a copy of this artist's painting online, and additionally said, so just print this out, with all the colors and frame it and keep it on your desk, and that should help to lift your spirits. I mean, that is a huge copyright violation, and someone inducing someone to infringe, not, in addition to them copying your work. There oftentimes people are hired to create something that would normally be owned by the creator, because those copyrights or those things that are created are initially owned by the creator. So say if someone hires you as a songwriter and says, I want or need a song written for my next album or CD or what have you, that is considered a work for hire. And so that through that work for hire, it would be owned by the person that is hiring you to create that work, or even your logo. So those are things that you would want to be mindful of as a business owner, is that when someone, for instance, creates your logo, that is a work for hire. And so if it's something that you create yourself, it's good for 70 years from the life of the author, or if it's a work for hire, it's 95 years from the publication, or 120 years from its original creation, whichever is first. And so what does a copyright notice look like? And sometimes it's just as simple as you put the C in the circle, or the word copyright, or you can abbreviate it, and then you put the year that say poem was created or that painting was created, and then your name. So it's pretty simple and straightforward. But again, if someone copies your work and you do not have a registered copyright with the Library of Congress, you cannot collect damages until you do that. So again, you create a song, someone hears your song, picks up your words and uses it, and say you were in a group, or say you made it up in some group discussion, and then next thing you know, you hear the words to your poem being used somewhere 2 years later, you would not be able to retroactively go back and pursue costs of infringement until the date of your registration. So what you would need to do is make sure that you have a copyright registration. And so what does what does the copyright provide you? And so it gives you an exclusive right for reproduction, for preparing derivative works, for distribution of copies, performances, and so on, and display. And again, it's emphasized that you must register that copyright to collect damages. The only exception to that is what we call the fair use doctrine. So for instance, when you think about teachers making copies of limited portions of someone's written work to teach a lesson, again, the typical lawyer answer is that it depends, like what's de minimis, and it's really just a small amount. And once you start to go, you can't go and copy the whole textbook. That's not de minimis. So those are just examples of what copyright infringement looks like. The next area of intellectual property is trademarks. And basically, a trademark protects your words, phrases, or designs or symbols that identifies and distinguishes products or services by your company from another company. So here you see some examples of different types of trademarks. And the main issue with respect to trademarks has to do with the class that your mark is associated with, and also whether your mark is confusingly similar to someone else. If someone else would accidentally buy another product thinking it was yours. So what it allows you to do, so you register these trademarks. And again, in trademark practice, you have common law trademarks. So, and I'll give you an example. Sometimes the best way to remember these things are when you hear stories about what not to do. Many years ago, there was a nonprofit organization that came up with a name, a very catchy name, and they did not register a trademark on this name. I'm sorry, no, they registered in Pennsylvania. But what they didn't know was that apparently another company in California had registered the exact mark for the same types of services. They provided a service to low-income families. And how it was discovered was that one day someone in California was looking for this company because they wanted to donate some goods. And somehow they discovered the company in Philadelphia. And they finally got a hold of the company in California, I believe in Los Angeles, that they were trying to reach. And they said, "Hey, I didn't realize that you had a division in Philadelphia." And they said, "We don't." And so what happened was the attorneys for that nonprofit then reached out to this nonprofit in Philadelphia and sent them what we call a nasty gram, a cease and desist. Basically, stop using that name. You're infringing our client's mark. And so while the company or the nonprofit in Philadelphia spoke to an attorney about this, as it turned out, that attorney was not as versed in trademark law and thought it was as simple as just filing the mark locally. And actually, in fact, not only was this group in Philadelphia, but they were in New Jersey and Delaware as well. So they could have filed for the federal registration. But what they didn't realize and didn't do a search to find out that this company in California had filed a federal registration to the same mark. And basically they had to go to their board and change the name. So just kind of imagine the nightmare that they had to deal with after they had built up goodwill in their business. They became very known in the area for what they did and by that name. And all of a sudden they had to go and change that name. The other thing too, and this is something that is really important to highlight, and this is why I initially indicated in this presentation that what you don't know can and usually will often hurt you. And you really have to be mindful of that. And I know as startups, especially, or small companies, you want to conserve your cash for, if you're a restaurant or what have you, you have to, you're worried about your building, your employees and so on. And quite often things like protecting your intellectual property gets put to the side because it's seen as something that's not really a necessary thing to do in the moment. And there are many entrepreneurs that figure, well, you know what, let me get myself off the ground, let me make some money. And then once I make that money, then I'll go ahead and apply for the trademarks and so on to protect my business. And again, something similar happened many years ago where someone was referred to me, and this person for about 3 years had been doing an online business I'll make it up. This wasn't the case, but say they called their business Books Are Us, and people would go to their website and they would order books and so on and so forth. And they thought, well, I can use Books R Us because I do know there's the Toys R Us company out there, but they sell toys, they sell baby items, they sell children's items, but they don't necessarily sell books. And this was really something that was way out of the range of anything that they would even sell. As I said, I'm making up books, but anything that they could sell that they thought under the Babies R Us, Toys R Us, or Kids R Us. And this person thought, I'll make some money, and then once I make the money, then I'll file for the trademark. And on top of that, he decided to file the trademark on his own. So he did not seek counsel to be sure that he would be clear to file for this trademark. So he thought, I'll save on the lawyer's fees and I'll wait until I have some money. And he filed this mark. And literally within a couple of months, because these marks and things, there are services that we can use and that a lot of clients use to police their marks. And sure enough, he popped up on the radar of the law firm that represented the Joffrey Company, which has the RS marks. And what he didn't know was not only did they have a mark to Toys R Us, Babies R Us, and Kids R Us, they had the registered trademark to R Us. So arguably, anybody who was trying to attach some product along with R Us could run afoul of their trademark and could be infringing. And there are nuanced differences to some of that, but those are the things that you want to be mindful of, that here he spent a lot of time and money building up his business, and more importantly, his goodwill. And then he had to come up with a whole new name, marketing materials. He had to destroy any letterhead he may have created. He had to take down things in his website, maybe even change his website name. So there's a lot that can cost you on the back end if you're not thoughtful and proactive about protecting your intellectual property on the front end. So that being said, there may be some of you who plan to start a business, and you're thinking, well, do I have to wait until I start my business to start considering filing for a trademark? And you don't. You can file in the United States what's called an intent to use trademark application, indicating that you intend to use it. And then you will actually, once you go through that entire process, identifying the mark that you'd like and under the class of goods or services that you want. And once you actually start using that mark, then you can convert it to what we call a use registration, as opposed to an intent to use registration. And as I said before, one of the hallmark determinations of infringement in a trademark is whether a consumer would be confused by the name that you use with respect to another product that's a similar product that's already out there. So, and whether there is a likelihood of confusion, whether there's an actual confusion. So for instance, you see I have a picture here of the Whopper, the sandwich, the hamburger, and then you've got the Whopper candies. No one is necessarily going to confuse. If you want a Whopper and they're not going to think or confuse the Whopper candy with the Whopper, I think that's sold by Burger King. And it's funny, I actually used to have some props where when I would teach this to students, I may have laundry detergent, and one's called Tide. And then I have another one in a very similar looking container, maybe a similar color, and it's called Stride. And the consumer could be confused. What was that, laundry detergent someone told me I should use? Was it Tide? Was it Stride? Well, let's see. How much is Stride? Oh, Stride is $1.50 cheaper than Tide. And chances are they may go for the less expensive item. But here, the maker of Tide just lost some of their market share because of that confusion. And that's what trademark practice, and frankly, intellectual property in general is centered around, and that is retaining your market share based upon your business and protecting that market share. And so you'll also hear trademarks, you'll hear the term trademarks or service marks. So trademarks essentially just identifies products or services in the minds of consumers that distinguishes goods and services from one another. Service mark is usually for service. So the trademark term is used for a product, and service mark is used for a service. But a lot of times those terms, mark and trademark, are used interchangeably. And so then when we talk about trademarks are typically adjectives, and so they should be followed by a noun, but they're usually, a lot of times they're not. So for instance, someone, when we cut our finger and we go to look for something to cover our finger, what do we ask for? We ask for a Band-Aid, right? But a Band-Aid is actually, I believe, Johnson & Johnson's brand name for a bandage. So it's a Band-Aid bandage, but you rarely hear it used that way. That, I want a Band-Aid bandage. Someone just says, can you get me a Band-Aid? Same thing, for instance, I use the example of Kleenex tissues. Often someone will say, can you pass me the Kleenex? It may not be Kleenex. It could be Puffs. It could be, it's a generic brand. But when you don't use or when companies don't enforce their trade names with the product, a lot of times those products can lose their distinctiveness. And that's a whole nother area, or they can become more generic. Another example is Teflon. Teflon is a coating that was created by DuPont to keep things from sticking and to a surface. But after a period of time, individuals would just say, "Oh, I want a Teflon pan." A pan basically covered with that surface, but it was it may or may not be, the brand, the DuPont brand of Teflon. And so the other thing is that I'm sure that many of you have seen trademarks with an R and a circle next to it. The R and the circle can only be used if you are granted a registration on your trademark. So that means that you've gone through the process of filing for a trademark registration, and that trademark registration has been granted. If it is not granted, you can use the superscript TM for trademark or superscript SM for service mark, which again, as I said, similar to copyrights, you can get common law trademark rights, that are limited to your immediate area. But similar to what I was saying about the nonprofit in Philadelphia, the difference was that the company that had the federal registration had actually applied for and received their federal registration long before that local nonprofit had even created the name. So even if they were using a TM or an SM, it would, it didn't matter because someone already had a registration for the same class of goods and services. So that's basically, what a trademark is. It's considered an adjective that identifies the noun that it's associated with. Basically, just a quick overview of how this process works. Someone will file a trademark application. Usually, you go to an attorney to do that, although individuals can do it themselves. I tend to tell people, just because you can do something doesn't mean you should. I'm quite aware that if I have a loose tooth, I'm not going to yank it out myself. I'm going to go to a professional, go to the dentist to take care of that. So that's another thing that I caution you about. Similar to the guy with the R Us, the books R Us. He thought, well, I can file this trademark myself and I'll save a bunch of money. And had he come to a trademark attorney about filing it, he should have been told immediately that that's something that he wants to, he would want to consider either getting a license, right, from the company that owns the trademark, if he was insistent on using the Books R Us, or coming up with something different, a different name. And so you would file for the trademark before the trademark office, the U.S. Trademark Office, and you would select the class that is associated with what it is that your product is that you're selling, or whatever the service is that you're offering. You would make sure that you select all of the classes that it relates to. And sometimes people might think, well, I've seen a certain trademark, registered trademark, owned by different companies. For instance, I mean, you look at the Whopper example. Well, one is a mark to candy, and the other one is to, a burger or some type of sandwich item. Same thing if you have, I use an example of like Apple. The other thing too is that you are not allowed to use marks that describe something, called descriptive marks. So when you think about an apple, the first thing, that people think of is the fruit. And so if I had a store, a bakery, where I sold all items that were apple pies and cakes and what have you, and to call that apple, I most likely will not get a registration to that mark, because I'm actually describing the product that I'm selling. And the reason that that's significant is because what you would end up doing is precluding other people from using a mark that is used to describe a specific item that everyone would use. However, if you decide you want to apply for a mark for Apple, but it's for computers, that's a computer doesn't come to mind when you think about the description of the term Apple in the dictionary. And so someone would be able to, of course, and has filed a mark to Apple as it relates to computers and the services and the products and so on that company provides. So once you file the trademark, it gets assigned to a trademark attorney, and what they do is a search. So you're not required to search and see if someone else's mark is already out there. But what I tell people, similar again to this nonprofit, had they come to me, one of the first things that I would have indicated that they should consider doing is to search and see if anybody else has a similar mark out there. Because if you're going to spend the money to file the application for it to be prosecuted, and then you're going to get the first action back that says, oh, sorry, you can't file for this trademark because someone else somewhere else already has this registration for this mark for the same class of goods or services that you're going for. At least you've saved the money from going through the whole process, and you spend less money to do a search. Again, the search is not required. The trademark attorney at the USPTO is going to do that search. But again, it has to do with, how big, when I say how big your business is, say you're creating your initial business and you intend to franchise the business at some point. You want to make sure that you're checking, under every stone to be sure that you are not going after a mark that could potentially be infringing someone else's mark. And so that's basically how the registration process goes back and forth with the trademark office. And a lot of times if they find a mark that is close to somebody else's, the trademark office will say, hey, this mark is already out there. You may have to distinguish it, or maybe narrow down your class, or your goods or services. And those are things that we as patent and trademark attorneys, or intellectual property attorneys, I should say, more broadly, are familiar with and can work to get around some of those, if you can at all. So that's how that process works. The next item of intellectual property protection is a trade secret. So that's anything which the disclosing party wants to keep secret. They usually include things like manufacturing details for products, and so on, formulas, patterns, designs, and it keeps these things. The companies keep these things secret to provide their business with an advantage. It's almost like the special sauce. And the reason I have the Coca-Cola logo there is that that's one of the more famous um, trade secrets. Is that they could have filed for a patent on their formulation, but way back when they chose not to, and they chose to keep it a trade secret. And it seems like I either read or heard somewhere that no two people have the full formulation of Coca-Cola. And I'm sure many have tried to reverse engineer it to come up with, that Coca-Cola taste, and have not been able to do it. And so that was a decision that the company made to keep that a trade secret. So even today, they are able to benefit from their trademark name. So when people see Coca-Cola, they know that that is the brand associated with the cola made by the Coca-Cola company. So there's their trademark. And then their formulation for the Coca-Cola is a trade secret. And a lot of times, and when I talk about a little bit about the patent space, there are companies that will keep certain aspects of their inventions a trade secret. So, and you're required to disclose information that will enable someone to basically recreate your product when it's a patent. But sometimes the patent holder may have a certain process or a way of manufacturing under certain conditions. It's almost like putting together a recipe, but you cook it at a certain temperature with a little bit of, maybe it's in a pressure cooker, and it just, when it's all done, it comes out with just the right taste, whereas someone else could put together all of those ingredients, at whatever temperature they choose, and it just doesn't taste the same. It's the same concoction or mixture of products, but those formulations or parameters are a lot of times kept a trade secret by companies. And so again, the things that can be kept a trade secret or information is not disclosed to the outside world, or where there's an obligation of confidentiality. So again, formulas, recipes, manufacturing process, software code, business information, sales data, marketing intelligence, your customer lists, and it has a value due to its secret nature. And so a lot of times, what you want to do as a business owner is protect your secrets, your company's secrets. So, people are under an agreement, a secrecy agreement or a confidentiality agreement. And, you have to make sure that your employees understand the obligation of keeping those things secret. Or you have third parties sign what's called a non-disclosure agreement. So say you create something, and I have people come to me often where they've invented something and they're really excited, and they want, I'll just make up something, like they'll come to me with a new kind of a diaper, and they'll say, there's nothing out there like this. And they'll explain it or describe it to me, and they're excited. They want to go to the companies that, make diapers to see if they will basically take their invention and run and create it and then give them a royalty. And a lot of times they want the companies to, you want to make sure that whoever you talk to about this is under a non-disclosure agreement, because it can and will backfire on you in the patent process. And I'll explain a little bit about that in a moment. And just other things like workplace procedures. You just want to make sure that the things that you believe are really very important and critical to your business, that no one else has kind of like figured out how to do it to make your product or your service better over your competitions. Those are the things that you want to keep protected by confidentiality agreements and so on. So the next is patent practice and patents. And so It's a legal right to a new and innovative article, process, or composition of matter. Patent must be granted by the government. In the United States, it's the USPTO or the United States Patent and Trademark Office. The patent and trademark parts are combined in one office. But when you go for a patent, you will be dealing with the patent end of the office, just like when you would pursue a trademark, you would deal with the trademark end of the office. A lot of times, clients may still be developing their invention. They've come up with something new. They believe that, no one has created it before, and they want to file a patent on their invention, but say that it's still in development, say they're still tweaking it a bit. One of the things you can do is file a provisional patent application. And a provisional patent application, I just simply say it gives you a place in line. It's not going to get picked up by an examiner. It's not going to be reviewed. It buys you a year's worth of time to tweak your invention a little bit more. And it also helps you to protect. So say you have a business and you want to pitch your idea, and your idea is something that could be covered by a patent. Before you disclose it, whether you disclose it to a third party, and I would say even if that third party is under a confidentiality agreement or not, it's just good practice. Or say you want to publish it. I had this happen recently where a client of mine is a university and wanted to publish a paper on an invention that was created. They did the right thing. They came to us and said, we want to publish this, but before we publish it, we want to be sure that we are protecting it. But we may not have all the information right now, but we want to protect what we have so far before we put it out there. And that's where you can file a provisional application to give some preliminary protection to what you've discovered so far. The other thing, too, that you have to remember is you have to be very careful with, if you've created something, an invention, you have to be careful with disclosing it. So say you're at a trade show, because the moment you disclose it, if you have not filed a patent application to that invention, whether it's a provisional, or in a moment I'll tell you a little bit about a regular patent application or a non-provisional, you start your time bar. So in the United States, you have 1 year to file a patent application on an invention that you have disclosed. The other thing that you have to be mindful of is, in many other countries, there are other countries that have what's called an absolute bar. So if you disclose it, you're out of luck. I think Japan is like that. I think Europe is like that. And so, I have a client that has patents on dental devices that are used to treat concussions. And he's done very well with this. Well, if you think, and it's usually directed to athletes. Certainly not the only area. There's military use and so on with respect to concussions, but even just thinking about athletes, well, there are athletes all over the world. So while, he's in the United States and that's something that he's pursuing in the United States, he has the intention of pursuing this, for instance, soccer play. You think about any sport that's played anywhere else. It's applicable to those athletes as well. So that's a part of his potential market share are other countries. So if he were to put this out in a publication before he filed a patent application, he could essentially shoot himself in the foot, in other countries that have an absolute bar to a disclosure about these things. So sometimes, as I said, a provisional patent application is just a placeholder. It's like standing in line for you. Because in the United States now, it is whoever files the patent application first is the one who has the opportunity to fully pursue the application. It was not always that way. It was a first to invent, but we are now first to file country. And I'll also quickly mention, while I'm thinking of it, whenever you speak to an attorney about pursuing protection on these things, or really anything, whether you hire that attorney or not, your discussions about this are a part of the attorney-client privilege. So sometimes people will call me and they're kind of tentative about telling me what their invention is. I can't help them until they disclose what their invention is. And I usually, relieve their concern by telling them anything that they tell me is bound by attorney-client privilege. So you don't have to worry about me turning around and disclosing it or that type of thing. So that's another thing for you to keep in mind. So then after 1 year, you have a provisional application, and typically you convert that provisional application to what's called a non-provisional or a regular application. And you can file a regular right away, but the difference is that regular patent applications get assigned to an examiner in the patent office that deals with technology that's the subject matter of your invention. So many of the inventions that I deal with are in the pharmaceutical and biotechnology space because that's my technical background. But not always. As I said, I have a client that has mouth devices and so on. But the provisional just buys you a little more time to add on to it. And then you also have a PCT or an international patent application. Like I said, with this one client that had the mouth device that helps to treat concussions, he definitely knew he wanted to file what we'll call sister patent applications in other countries beyond the United States. And so the least expensive way to pursue it initially is to file what's called a PCT or an international application. And it's almost like a one-stop shop for about 153 countries that you can go into. You just have to make sure that the countries of interest are signatories to this PCT. It's a patent cooperation treaty. It's a treaty between these countries, basically saying that we all agree to abide by the same kind of rules. But then there's some countries that have not signed on to that. So you just have to make sure that you know what countries you're interested in. And so, what makes my invention patentable? Well, it has to be something that's new, meaning no one else has created it before and it's not publicly known or used or previously disclosed or on sale. As I said, if you go to a trade show, you can't, you have to be mindful of disclosing things or selling it. A lot of times as entrepreneurs, you're excited to sell your first widget, and if you have not pursued patent protection, you really could have just done yourself a huge disservice and by not filing a patent protection. And again, it has to be new and not publicly known. Give you another example, someone from my church, and you'll see why I can tell you this example, because I did tell you that when someone comes to speak to you, it's a part of attorney-client privilege and is confidential unless it is already out in the public domain, unless it's already out there. So someone came to me about a detachable bed skirt. Kind of, like when you have the bed skirts, normally it's like a big sheet with a border and you have to pull up the mattress and get it under there and put the mattress back down. And as you can imagine, it's a lot of work to do that. And so this person had come up with the idea of a detachable bed skirt where basically you fix it or affix it to the box spring, maybe with Velcro or something like that. And then you end up, you're able to put it on and put it off and change them. And I said to him, well, I'm not sure if someone else has created that. And he said, I haven't seen it anywhere. And a lot of times business owners or startup businesses create a product, and because they haven't seen it on the market, they believe that nobody else has done it before. And I haven't seen it in the stores. I Googled it, I was online, didn't find it. And what I explained to him was that just because you can't find it out in stores or online actually doesn't mean that someone else hasn't already filed a patent application to it, or may even have a patent issued to it and just has not been able to take that patent to the next step and create their product to monetize it in their business. So sure enough, I did a quick search. And again, searches are not required, but I recommend them because it's like an insurance policy, because you don't want to go through spending lots of money to pursue a patent only to find out that somebody else has already done it. Sure enough, I did a quick search. Literally 2 months prior to the time that he called me, someone was just issued a patent on a detachable bed skirt. So that's why I could tell you the story, because it was already out there. So if it has to be new, it can't be the same thing that's already, out there. And it has to be non-obvious. It can't be an obvious combination of two things that someone skilled in, say someone skilled in making food might think. If they made hamburgers and they made grilled cheese sandwiches, they may say, hey, why don't we just put some cheese on the hamburger and make a cheeseburger? It's that would be obvious. So what your invention should be is something that's not obvious. Another quick example are medications. It may not be obvious to combine certain medications. There are medications now that companies are combining because they have what's considered a synergistic effect. The two drugs work together and have either an unexpected result or a better result for a patient. And it keeps the patient from taking the medication, two medications a couple of times a day, where you could take one combined a couple of times a day, or say, for instance, another potential way of something not being obvious is that you have a drug, and say you have a drug that's given 3 times a day. Well, one of the benefits of reformulating it, right, making the same drug but in a different way, is that you may be able to formulate it in a way where a person takes it once a day and it acts like you've taken it 2 or 3 times in a day, and it has a sustained release. So those are some examples of non-obviousness. So what do patents do? It grants you the right to prevent others from making, using, selling, or importing what it is that you created. The reason that this is significant is that, and a lot of people have a hard time wrapping their head around it, a patent does not necessarily give you the right to create your product. It gives you the right to keep someone else from creating your product. Let me use another example in the pharma space. If you've got drug A and drug B, and company A has a patent that's valid on drug A, and company B has a patent that's valid on drug B, but you have been doing research and you found that if you combine drug A and drug B, that it has some totally different use that you didn't expect. While what you have discovered is the new thing you've discovered is combining the two, drug A and drug B. And that could be patentable because nobody else came up with that discovery, and it may have some effects that no one expected, or you can tweak it a little bit. It does not necessarily give you the right to use drug A and drug B, because guess what? Company A and company B still hold a valid patent to that. And so what it does is it keeps everybody else from combining drug A and drug B to make your invention, if I'm clear about that. Or what you could do is seek a license too. That's when you get an opportunity to seek a license deal from the companies or the makers of those two drugs. But the thing that's important to remember is that it's a negative right. Another example is you may have a tweak to a brake, a car brake. You may have a tweak to the modification of the anti-lock system. Well, you can keep others from using that anti-lock system, but that doesn't mean that you get to use the whole brake system and put your little piece into it to sell that whole brake system with your modification. It just keeps others from using your modification. So what it does is it puts you in a position to license what you've created and hopefully go from there. And inventions are, if a patent is granted, it is from 20 years from the filing of that patent. It used to be 17 years from the issuance. That rule and law changed. It's now 20 years from when you file your priority. So from the date that you filed your provisional or your non-provisional, and your once that patent issues, then it's good for 20 years from the date you file it. But you can't assert it until a patent issues. You can't assert a patent application just because you filed an application. It has to go through that process. And again, as I said, you can get a patent on improvements to things that were previously patented. Here's an example, an amped up bacon cheeseburger, and then again, similar to the trademark process, you prosecute patents before the United States Patent and Trademark Office. And I call it the tennis match. So you would come to someone like me, who's a patent attorney or a patent agent. Inventors can do it themselves, but again, I'd still go to a dentist if I had a loose tooth. You have to really know what you're doing and prepare a patent application. You file it with the patent office. So it's like playing tennis. You lob it over to the patent office. They're going to do a search, see what's already out there. 9 times out of 10, they will come back and reject your application. I can't say that enough, because if you don't know how this process goes, you may think something went wrong. Like, what did you do wrong? Because just got this rejected. It is very rare. I think only one time in my 25-year career did someone get a patent issued after a first action, where basically they reviewed it and said, we think you have something that's patentable, and the issue a patent. And that's basically how it goes. And you go back and forth until a point where if you still can't get it, you have the opportunity to appeal it. The claims of a patent kind of just talks about the territory of what it is you've invented. Similar to, I use the example of a real estate property. You have the metes and bounds of your property. Intellectual property, you have the metes and bounds of what you have created with your mind, and is in your patent. And so just something really quickly, I'm recognizing the time. The patents are initially owned by the inventors, but you want to make sure that your employees have the obligation to assign their rights to their patents if they're created as a part of their job, say the company that you own or that you run. You want to make sure these things are in their employment agreements, and you have to be very mindful to put the correct inventors on a patent application. You don't want to put your kids on it because you want them to benefit from the patent. A lot of times you'll find CEOs will say, put my name on that patent, on that patent application. And the CEO had nothing to do with creating the invention, because it could render your patent, if it's issued, invalid. And again, so patents are owned by the inventors unless assigned to a company. Copyrights are owned by the creator unless expressly assigned in a work for hire. Be mindful of consultants and contractors and things like that, making sure that they sign those agreements to make sure that your company ultimately owns your intellectual property. Sometimes people will come up with an idea but not really know how to make it happen. You can't patent an idea, but say, for instance, if I come up with a jacket that makes you fly, and then I have to go to an engineer to actually create that jacket, the engineer and I would be inventors. So that's something important to know. Make sure you use confidentiality agreements. Make sure you get assignments of your inventions. You have work for hire clauses, non-compete clauses, and it should be signed at the beginning of any employment. And so these are just some of the things that you want to, that can be a pitfall if you don't have these documents and so on in place. And, educate your employees about, keeping things trade secrets and have the appropriate documentation and agreements in place. And that's it. So I don't know if we have much time for questions. Evelyn, I don't know if you've received it.
Right. We don't have that much time. I think we have a hard stop in the next 2 minutes. But I'd like to just wrap up with one question that came from Kim in terms of the logo and the name of the Chamber of Commerce. Can we go back to our ad for this presentation, just the very, very beginning?
Oh.
Yeah. So we can see the Chamber's logo and
there we go.
Right here. So I don't know if we can zoom in. So does our business logo fall under copyright law or trademark law, or both, the symbol and the phrase under it? So what do you think?
So I would say that this is a logo, so it would be filed as a trademark. I'm trying to see. I can't see the details on this. Let me see if I have it.
It just says Chamber of Commerce underneath, and then the word Norristown right above it.
Oh, I see something in green. I thought maybe she was referring to what's written in green. It's like micro print underneath it. But that would be the subject of a trademark for a logo. And I guess to that end as well, you know, if anyone has any questions or wants to talk further, I'm more than happy. I put my contact details at the end. And you can certainly feel free to reach out, or Kim, let members know that they can reach out, and I'd be more than happy to talk to them on an individualized basis, to see if you know, see what they may have and give them some guidance about what they need to do to protect their intellectual property.
Thank you for that.
Mary Lou, what is the average cost on something like this?
You know, I'm gonna give you the average lawyer answer. It really depends. It depends on, for instance, let's use a trademark, right? So say you're applying for a mark in multiple classes. Well, the trademark office charges, I think, $275 for every class that you select. So, you know, I had a client recently file in 5 different classes. So at minimum, that is the out-of-pocket cost that you would pay to the trademark office just to apply for a mark to those classes. And then probably the typical amount of time, again, it depends on how straightforward or complex the application may be. It depends on whether somebody else is already out there doing something in a different space, and we want to make sure that we don't overlap. That takes time to kind of think of ways to get around that, but still give you in your business as much of a full scope of what you're trying to cover. So I hate to say it depends, but it really does. I mean, kind of like, you know, an average, what I'll call a quick and dirty search. And a lot of times too, I will share with clients ways that they can do searching, with the caveat that, so they could do it themselves, with the caveat that, again, the search is only as good as the searcher. And so it's not a fail safe that I've searched everything. But a lot of times too, I will give especially startups some tools to do those searches. And we, like, for instance, our firm provides a toolkit where part of the toolkit, startup business toolkit, part of the toolkit is a trademark search. And so, but it's a very minimal type of a search where we would probably look at the trademark office and check some things on a website. But it's not a deep search that you would get. That, frankly, again, a lot of times we may have an outside group do a search. That outside group could do a very thorough search, and the search alone can cost $1,500. It depends. It really depends.
Okay. Well, thank you everyone for allowing us the opportunity to make this presentation, and you have Mary Lou Watson's contact information, and we look forward to seeing you again. Thank you.
Thank you.
Thank you, Mary Lou.
Thank you.
Thanks. That was very nice.
Very informative.